A deposition is a question and answer session under oath. The purpose of this video is to help prepare you for a deposition. And it's very important to take the time to watch this video and write down any questions you may have that we don't answer. It's our attempt here to try to answer some of the most common questions about a deposition, because most of the time it's unfamiliar to people.
If you've never been through a deposition before, it's basically just a question and answer period. There's going to be an attorney representing the defendant or the insurance company who's going to be asking you questions. There's also going to be a court reporter in the room that's going to be taking down everything that's being said. Everything that's said is then going to be put into a booklet, and that booklet can be used at various times throughout the case. If we were to go to an arbitration or a trial, that attorney will be able to utilize that transcript to show how you testified at the deposition. Because the court reporter is writing down everything that's being said, all of your responses need to be verbal. She can't take down head nods or hand gestures or mm-hmm and uh-huh. So all of your responses have to be verbal.
The point of a deposition, from the defendant's perspective, is an opportunity to evaluate you face to face, get a sense of whether or not you will make a good witness in front of a jury. So they're there to evaluate your credibility. They're there to listen to how you answer questions and really get a sense of whether a jury will like and believe you. The most important instruction to remember throughout this preparation session is to tell the truth. It's very important to remember that the deposition is not your time to try your entire case. It's not your opportunity to put your entire case on trial. The deposition is an opportunity for the defense attorney, the one and only time for the defense attorney, to question you under oath before trial. So it's very important to remember that you're there to answer questions truthfully and honestly, but you're not there to volunteer information. Volunteering information causes the deposition to go much longer because you now are providing more information for the defense attorney to question about. And it also opens other doors in a case that potentially may not be open.
No one's going to be asking you questions and trying to trick you, but the attorney who's asking you the questions does represent the defendant and the insurance company. So you want to make sure that you fully listen to the question that is being asked. But even more importantly than that is you want to make sure you fully understand the question before you've answered it. If you don't understand the question, you're going to tell the attorney, I don't understand the question, and ask them to rephrase it. If you still don't understand the question, you tell them again. The last thing we want you to do is to answer a question that you are not fully sure you understood. Same thing goes along lines with the answer to that question. If you don't know the answer or you don't remember, that's a completely acceptable response as long as it's a truthful response. The attorney may ask you to estimate or approximate. Only do it if you can. We never want you to guess here today. Now, a lot of times at a deposition, you're going to be asked questions that you may think, how is that relevant to my case? Or why are they asking those types of questions? And you may be completely right. If your case was ever to go to a trial in front of a jury, those questions may never be permitted, because in front of a jury, the only thing the jury is allowed to hear is admissible evidence. But at a deposition, the attorney is allowed to ask you any question which could lead to admissible evidence. They're going to start with background questions. Who you are, where you're from, what do you do for a living, do you have a family, do you have any children? Questions that are easy that you know the answer to. A part of that is because they want you to feel comfortable. They want you getting used to answering questions, to start to trust them a little bit. They're going to know about all prior medical conditions or prior accidents that may be the cause of your current symptoms. After they go through background, prior medical conditions, a lot of times they'll then get into the incident itself. Some attorneys will ask a lot of questions about the incident. Others may just gloss over it depending on how tough the liability picture is on the case. After they go through the accident or incident itself, they're going to go into your injuries. What got hurt in this incident? And then immediately after the accident or incident, what medical treatment did you have? Did you go to the emergency room? What was the first doctor you followed up with? What type of treatments have you had consistently throughout the life of the case? After they go through your medical treatment, they're going to then get into your current medical condition. How are you doing now? And when they ask you those questions, they're not necessarily talking about right at that moment. They're talking about in the weeks and months leading up to that deposition, how are you doing? And then a lot of attorneys will then get into, how has your life been impacted? And usually they will ask that in a two-part question. The first question they'll ask you is, what activities can you no longer do at all anymore? Meaning you've given them up 100% as a result of the injuries that you've sustained in this incident. Then they'll go into the second part of that question, which is, what activities do you still do, but you're limited, you do them less often, or they cause pain when you do them? Now, it's very important when you're being asked those questions that you try to remember every single way that your life has been impacted. And it's hard, but it's very important that you let the defense attorney know that there are multiple ways that your life has been impacted, if that is in fact the truth. What we need to be careful of is when they ask you an open-ended question like activities that have been infected, and then they follow it up with, have you told me every single way that your life has been impacted? It's very important to not just answer yes, because now you are locked into that. If you did forget something, you forgot to mention something. Now, a few months down the road, we go to a trial, and you do remember a different way that your life's been impacted. That attorney can pull out this deposition transcript to say, I asked you 3 months ago if you told me every way your life was impacted, and you told me yes. But there will be an attorney from my office there with you that will object to any questions that they feel are improper. If you hear your attorney say objection, do not answer the question. Wait until the attorney has finished his or her objection, and then he or she will instruct you whether or not you can answer the question. Usually in a deposition format, the only time that the attorney is allowed to instruct you not to answer the question is if that question is going to violate the attorney-client relationship. If that is going to occur, then your attorney will tell you, do not answer that question. It's going to violate our attorney-client relationship and you will not have to answer it. If you don't understand the question, you're going to tell the attorney, I don't understand the question, and ask them to rephrase it. If you still don't understand the question, you tell them again. The last thing we want you to do is to answer a question that you are not fully sure you understood. Same thing goes along lines with the answer to that question. If you don't know the answer or you don't remember, that's a completely acceptable response as long as it's a truthful response. The attorney may ask you to estimate or approximate. Only do it if you can. We never want you to guess here today. Now, you've heard us talk about answering a yes or no question with a yes or no and not providing too much information. The only time that's not going to apply during your deposition is when they're asking you about the impact this has had on your life. We don't want you to exaggerate. We don't want you to talk about things that aren't true. But we need to make sure that you fully explain to this defense attorney all of the ways that your life has been impacted. Don't think that you need to come in and downplay it and act like it's not that bad. This is going to be your only opportunity outside of going to a trial to let this insurance company know all of the ways that this accident or this incident has impacted your life. So don't hold back when you are describing your pain, when you were describing your limitations, when you were describing the impact that this has had not only on you, but your entire family. 95% of what a deposition is really getting to meet you. A lot of times before you come into the deposition, that attorney already has all of your medical records. They've already seen everything that is relevant to the case. The deposition is an opportunity for the name that they've seen on a medical record to now put a face to that name. We really want to leave that deposition with that attorney for the adversary, for the insurance company, saying to themselves, wow, what a nice person that was. What an impact this accident has had on them. And then they go back to the insurance company and they tell them that. So don't try to be too combative with them. If you find yourself getting a little bit irritated, sometimes it's just annoying having someone ask you a bunch of questions. Take a break. We are permitted to take as many breaks as you want during this deposition. You are in charge. If at any point you want to take a break for whatever reason, you just turn to your attorney and say, I want to take a break. But try to stay calm, try to be cordial, and do not take out your frustrations on this attorney. The reason it is so critical to be honest, truthful, and thorough at a deposition is because all of your testimony is then going to get put into a transcript. And that transcript can be used throughout the case. If the insurance company doesn't do what's right and make you a fair offer, our only recourse may be to go to a trial. And if we go to a trial one day, you're going to be on the stand in front of a judge and a jury testifying. If you are to say something different than how you testified at your deposition, that defense attorney would have the ability under the rules of court and the evidentiary rules to take out your transcript from your deposition and cross-examine you with it to show that you testified differently to the jury than you testified at your deposition. We're going to send you a copy of your transcript. Keep that transcript in a safe place because we may ask you to review it again before an arbitration, before a trial, so that you remember how you testified, so that we can be consistent in what we've said.
You just finished watching the video regarding preparing for your deposition. There's a lot of information contained in this video. There will be another opportunity to meet your attorney in person and prepare for the deposition and focus on specific factual questions or issues you may have. The purpose of this video was to give you an overview of the process, hopefully start you thinking about it, and hopefully you have some questions. So if you do have some questions, please do not hesitate to reach out to us. We will make ourselves available.